As the Aretha Franklin case proceeds through the Oakland County Probate Court, I thought it would be good to discuss what constitutes a valid will in Michigan. Hi, I'm Darren Findling from the Probate Pro, and wills don't always look like that beautiful document that come from your lawyer's office. Often wills are found in strange places and under very strange circumstances. There's a famous story of an individual who got trapped underneath his tractor, and he etched his will, his wishes, his desires in the fender of the truck that he was trapped under, and he ultimately died. And that etching what constituted a valid will. And we know that there are famous cases involving people who are trapped in caves or in mines, and they write on the walls their expression of their last will and testament. In fact, the medium, the document, and the method of signing isn't all that critical in certain circumstances. Lipstick, fine. Toilet paper, we've seen some on. We've seen writings on envelopes, scribbles and writings chiseled on stone, all sorts of really unique papers and medium upon which the writings are represented, and those can constitute a valid will if, of course, they follow the format, requirements, the elements under Michigan law. Now, oral wills where you're simply expressing to another family member your desires or your interests, are generally not valid. And I think it's pretty logical the reason why. Imagine if the person before they died tells one child one thing, and of course the other child another thing, because they want to make sure that both of their children love them, and then when they die, one person receives to the detriment of the other. The oral expression doesn't have enough permanency or credibility for public policy to want those types of wills to be legitimate. So oral wills are generally impermissible, not constituting appropriate wills in Michigan. It's a very interesting case that just came out in which somebody used a cell phone to identify through text messages an expression of their testamentary intent or desire, and the Michigan Court of Appeals found that actual document to be a testamentary device. A little bit more detail is needed to fully explain how that works. There's also a really famous case about the man who created Pringles, of course, those delicious crackers that we love to eat. His name was Frederick Bauer, B-A-U-R. And he had told his families that he wanted to be buried in his own invention. Amazing, right? Buried in a Pringles can, or his remains placed into a Pringles can. And of course, that expression orally was deemed to be an invalid expression to form a testamentary device. And when I use the word testamentary device, I mean a valid will. So what is a valid will? Well, there is a statute in Michigan, MCL 700.2502, that defines the elements that are required for a document to be deemed a valid will. One is that the will must be in writing, and this is where we talked about the oral wills, or oral expression of intent or desire. It must be in writing. What that writing looks like, there's a lot of interesting things that can occur, but a video expression of your intent doesn't constitute a writing. So a writing has to be done something actually etched or inked. Color of ink, not relevant. People often ask, blue ink, pink ink, black ink. No, it doesn't matter. In writing. The will is signed by the person who's making it, that person called the testator. The person who's creating the will has to sign it. Now, there are some exceptions to this, especially in situations where the person isn't well enough to sign, or maybe they use their thumbprint. There are some exceptions to what it actually means that it's signed by them. If it's not signed by them, it can be signed by another person at their direction, and this is fraught with all sorts of potentials for legal challenges. Imagine a fight, and they said, well, they didn't sign it, they told me to sign it. That can obviously be an ingredient for a will contest case. A will must be witnessed by at least 2 persons within a reasonable time after the execution. And this issue often occurs, fails to occur. Sometimes we see wills with 1 witness, or the length of time is too long. Michigan has a savings clause that says that if it's substantially compliant, if the will, we shouldn't throw wills away because there's a minor defect. So there are some exceptions to that 2 witnessing requirement. We've also seen, for example, people would sign the will at the witness spot, and the witness would sign where the settlor is to sign. And those types of defects used to be fatal to the admission of a will. And now Michigan law gives more leniency to the strict compliant signatures that were required under previous Michigan law. So if it substantially complies with the testamentary requirements under MCL 700.2502, a will can be found to be legitimate even though it technically fails for one of these reasons. A will still can be valid even if it's not witnessed, if it is dated and in the testator's own handwriting. So if somebody, for example, writes out a suicide note, we see these often, and it's dated and it expresses testamentary intent, or if it's not a suicide note, but simply a handwritten testamentary expression of intent that it is intent to create a will, it's dated, and it's signed by them, that document is what we call a holographic will, and that will, of course, can be valid. Now, this presentation is not a full explanation of all the nuances relating to whether a will should be drafted a certain way. Now, we obviously, I almost feel silly saying this, but you should hire a competent lawyer who is skilled in this area to make certain that you draft the will and the estate plan was thoughtfully done by specialists in this particular area. But there are things that happen even after the execution of a will or a trust that can cause all sorts of problems, including people want to make changes, so they actually write on the original document and they start crossing things out and putting lines and X's. Those can also cause huge problems. So the goal here is to give you a basic understanding of things that could be deemed valid or things that could cause you problems. But of course, hiring a competent lawyer will solve, hopefully, all these issues to make certain that you create an effective estate plan. My name is Darren Findling, and at the Probate Pro, we love talking about these issues. We litigate issues involving will contests and fights over the validity of a will. We administer the estates when somebody has died, and we plan to avoid those types of problems. If you've got questions, visit us at theprobatepro.com or call us 877-YOUR-FIRM.